Sorry, I have seen, say it is situated at the border or within the village. I have read the brief. Can the PIL lie of such nature? Then you impose. These are the all policy decisions of the government, whether to name a school by the name of A, B, or C. Can a mandamus be issued? It's a PIL. Because some section of the villagers they wanted.
See,
There is a complete misnomer in this form, with all deepest of respect. Just come, that becomes a PI.
how? Then why not permitted to withdraw and will approach the.
No, it's up to you. This cannot be. If you want me to dismiss the matter, this is not a PI.
Yes, please. Liberty to approach.
What liberty? No liberty is granted.
Approach the authority, government.
We can't. That is another avenue of directing the authority to consider the representation.
Only
No,
liberty
we
with
can't. That is up to you. You have already approved the authority.
yes.
Item number 2.
Withdraw.
Where is your lordship? So the petitioners here are tribal villagers of Rangavadi village.
The Gochar land, this was according to you, the Gochar land has been
Yes, your lordship.
have been dissected, some portions are there.
Yes,
Now, the Gochar land can be, the conversion is permissible.
Your lordship, it's only.
Just 1 minute. Is the conversion permissible under the law? Is, have you initiated a proceeding?
Yes, Param. It was Param.
No, madam, if it is permissible under the law, if you haven't done it, then in that event, you'll have to challenge that order of the government that the conversion should not be done.
Your lordship, they
How
have.
many, you have said 4,000 cattle.
Yes, your lordship.
How many villagers are there?
600 families, your lordship.
600 families, each family normally consists of at least 4 persons.
Yes, your lordship.
So 2,400 is a normal mathematical precision.
Yes, your lordship.
And 4,000 cattle.
Yes, yes, your lordship. Your lordship, the process for de-reservation.
Is it believable?
Millard, in the meantime, I have received instruction in this matter, Millard.
Instruction.
In that particular place, Millard, 64 acres of grazing land is also available.
Your lordship, there's a ROR attached which clearly shows that grazing land is only 35 acres.
No, don't go back. You have only gone to certain portions. Now they say that this land is there.
Your lordship, the ROR.
Is there any reporting that is because of the dearth of the food for the cattle have died?
I apologize, your lordship.
The cattle have died or they have departed. Whatever is the reason, simply the butcher land has been dissected or have been appraised, that does not mean if there is enough resources for the cattle.
Your lordship, since this is a communal land of the villagers.
So that's why, madam, the first thing is that there are 2 aspects.
Yes,
If it is already recorded as a butcher land,
yes.
and if there is a complete prohibition in the act that this butcher land cannot be converted into any other category of the land,
Yes, sir.
I appreciate it.
Yes.
But if it is permissible, if the car if you think that it has gone, we shall keep that particular decision of the land.
Your lordship, by section 3A of the OGLS Act, a certain procedure is provided for the
They
de-reservation
say
of
that they
the.
have followed.
It has not been done, your lordship. There has been.
Where is your case? You have not made out the case of conversions. Madam, I have read your plea.
I have, your lordship. It's there. It's
Please,
pleaded.
first, you
Yes.
simply say that they have dissected and given it to somebody else. You have not challenged that they have not followed the procedure. The conversion proceedings have not been initiated.
Yes, your lordship.
Where?
It's there in page.
It was.
Yes, your lordship.
Yes.
In the grounds. I've mentioned.
Now tell me again, I am saying, I
Yes.
have come from a court where the pleading has a very important role to.
Yes, your lordship.
Whether the grounds is a part of the affirmative statement or it's a submission. Tell me.
Your lordship, here I'm.
I'm asking you, sir, the grounds which we say is always considered to be a submission. On these grounds, we submit that this has to go, but with affirmative assessment. A state.
Yes, Your Lordship, in paragraph 8 of my pleadings,
Yes.
in page 6, I have stated that
Yes.
the third line, without any prior notice to the villagers.
Is a necessary conversion procedure.
Yes, Your Lordship. A
I am
notice.
asking, I have read, I am reading for you.
Yes,
That besides the described land, there is no other gochar land available for the villagers. First sentence.
yes.
From the total area of 35.0 decimal of gochar land available to the villagers, the district administration has already erected a boundary wall around 30 decimals of land, grazing area, and are in the process of filling up the same with the same.
Yes.
It is apparent fact that barely 5 decimals will not suffice for grazing of over 5,000 livestock. The only form of grazing land available to the villagers for their cattle is described where you have met out of case.
Your Lordship, paragraph 8, page 6.
Paragraph 8. The villagers used to celebrate CORAM
Yes.
in the compound. How can in the compound of DAV within the, but now without any prior notice to the villagers, the district has decided to observe and for in a gochar land is described. That is a different issue.
Yes, Your Lordship. As
You are concerned with the taking of the gochar land and using for other.
Yes, Your Lordship. As described, for which they are seeking to change the nature and character of the said land. The said land being the present land, the Gochar land. It is of note that no consent was obtained from the village.
For organizing or holding the forums. Sir, when some festivals are there, then it is, as we know in those Britishers' time or in that, certain lands are recorded as a Eidgah to be used for the purpose of a particular performance of the rituals. But that does not mean your concern is you can't dissect the gochar land for any other purposes.
Yes.
Conversion, complete prohibition, or there is a procedure to be.
Yes, Your Lordship, the
Sorry,
procedure.
to be, madam, since you are a junior member, I give you an opportunity. You should ask. I can't do it in this. You should know how to draft a PIL. You can't settle your personal scores through PIL. Can't.
Your Lordship, in that case, I pray for another opportunity to.
No opportunity. Where you have given me instruction unnecessarily, I will not keep it, madam. What are you giving?
You have to do that.
Sorry, madam. Without adverting to the nuances
This is petition on nature of public interest litigation relating to illegal operation of brake claims in the district of Punjab.
Are they using the kill for the first time? You have said many schools, 50 meters, 60 meters, 70 meters. And then these schools were situated prior to the kiln being allowed to operate or were constructed subsequent to. You have to disclose the fact. This is very important. If somebody decided to construct a school by the side of the kiln, which is operating since last 100 years, and then come forward and says, look, the school is at the parameter of 50 meters.
Well, may invite my lord's attention to,
Tell us,
but there is specific guidelines, my lords.
I am asking you the first question. Tell me, you are talking about these institutions being in a close proximity of the kiln. Whether these institutions were constructed after the kiln started functioning or
I have to take
prior
instruction.
there.
I have to take instruction.
What is that? Why you are drafting up here, don't you know?
Because there are specific guidelines that within that meter, if they
Sir, again I am saying, sir. Question is this.
I didn't inquire about that. The reason being, my lords,
Well, it's received instructions that the claim has already been closed down and penalty has been realized, my lords, and
So
that-
they, prior to the kills, those institutions were there.
yes, my lords, and the school is 800 to 1,000 meters. It's also mentioned in the instruction. It's 800 to 1,000 meters from the claim, my lords. It is 800 to
So you
1,000.
have already closed
Yes,
up.
my lords, already
There
pending.
is nothing.
Oh, my God.
The public facility should be resolution. Calculation of the display.
Item 5.
Oh, five also the same.
Six.
Six also. Yeah.
Six
Only one after the other.
Item 6.
Six.
Item number 7.
Yeah.
Item number 8. Item 9 to 18.
No, this is what I heard. I know the 1930 that.
Yeah, let's say. I didn't-
Today, for
Yeah.
some reason. I have read. Glaxo-kill. There are two categories I can understand. I can divide it. One category of the requisitions where the appellate organization has rejected the application for condonation of delay on the premise that exceeds the outer limit. One. Second is, there is no approach made to the appellate organization. And a direct challenge is made to the writ court. I shall segregate these two classes of the availability. Calls.
Falls in a third category.
You have two categories.
No, in my case, so far as item number 9 is concerned, Lord, I am an unregistered dealer whose registration has been cancelled with effect from 2/7/2017. They will not pass an order as an unregistered dealer, upload it in my flat email. Lord, once your lordship knows that.
It's the.
Sorry, Lord?
You did not have.
I did not have any knowledge. First,
This is not a third category.
your lordship.
Only thing is, there are two categories. So we have to first consider. Again, I am saying, whatever be the facts. If somebody has approached the appellate authority. And the appellate authority has decided something. Not on merit. But on the ground that you have come beyond the outer fair. Then even if you have the best case of merit. Whether the court will entertain such kind of a request. Second is that you have approached the court. Without approaching the appellate authority. But beyond that outer limit. Third category, I can say that the approach is made within the limitation. Without approaching the appellate authority. Then what should the court do in such situation? If the court intends to relegate, that is one, or court may, because the alternative remedy cannot be an absolute bar in entertaining the writ petition. So we understand and appreciate this. But these are the largely the cases where approach, when the writ petitions are filed under first two categories. One, after approaching, dismiss on the ground of limitations, and after the limitation period has expired, have approached. So these two
At the date of
categories-
knowledge.
So I have seen the best, the Glaxo-kill. I tell you very frankly, in the morning I had one of the matter, I think that's the highway authorities. They have given a particular comparison or means composite
This matters to petitioner. And my respectful submission, what the matter is.
Yes.
In my respect, submission of this matter is getting a little derailed in this auction price and discovery. If your lordship will just come to a little bit of background without opening the brief, just leave the background, just come to the background. The lordship will recall that the industrialization, private industry came into India only after 91, when the government decided to open up. And various states were competing with each other to bring in investment. Orissa also likewise was in the same law, who trying to bring in investor. If your lordship will see today's scenario, when we decided to come in, there was no question of auction of mineral. We came in at the regime. The lordship will recall the auction of minerals started after M.L. Sharma, 2014. And after 14, this mineral concession rules got framed in 15. And these auction rules were framed in 16. Prior to 15, the law on mineral was simpliciter, extraction cost and royalty. What is ultimately royalty? Royalty is the price that you pay to the government for using that mineral. Ultimately, mineral is all government property. So royalty is the price of the mineral which you pay to the government. And extraction cost, if the government is doing, the government will do the extraction cost. I will pay, if I am doing my extraction cost, I will bear it myself. So when this industry came in 2003, there was no question of not payment of any mineral. The law did not require not payment of any mineral. The law did not require not auctioning of land. This auctioning of mineral started only after 15. Admittedly, Lord, I came in 2003. I had an agreement with them in 2004. And in the agreement, I'll come to that later. Lordship, I'll just give a very brief background what I'm trying to say. Then your Lordship will agree. In the agreement, there was a promise. And that promise had a trigger. The trigger was that after I invest a certain amount of money, the promise will become effective or enforceable in that agreement. And they waited for me to do that initial investment for the trigger to happen. And the trigger was not to assure me 150 million tons of bauxite, 115 million tons of bauxite at a price, extraction cost plus royalty plus 50% of royalty. Extraction cost, royalty plus royalty, another 50% of royalty. That is in the written agreement.
Additional tax.
No,
I
no,
think in the concession rule, there is a word of additional
yes, so it was.
fees or additional, what is this?
So this was in the form of royalty only. In our agreement, it was the nomenclature used in our agreement was royalty. Now, Lord, today we have invested about 1 lakh crore in the state of Orissa. And this investment, Lord, started 2009 and all our plans were all set up. It's not as if we have set up after 15. 15, there is nothing happening after 15. And your lordships, if your lordship will see the national.
Was there any incentive schemes at the time when this particular, the modalities was adopted by the state?
There was any scheme, had a separate agreement with the state. The state had called us and we had a separate agreement where there was not milestones, and only after a certain investment the milestones kicked in. And I performed those milestones for the cricket to happen. Today, Lord, out of 150 million tons of bauxite, I have been given only 20 million. And we are grappling for price for that 20 million tons, is what is not happening. Lord, an industry which is coming with a promise that I will be given 150 million tons for the purpose of setting up the industry, admittedly knowing that there will be no price, there will be no auction price. Admittedly knowing that there will be no price discovery. it was to be only,
Was it a fixed price or price?
no, the
can be
price
or
was,
modified or something?
no, the price was very clearly said in the agreement. Price was the extraction cost.
I have not read it. That's
No,
why
I'll explain.
Those-
I'll figure out into the document. The price for the cost of extraction plus royalty plus 50% of royalty.
Royalty pays the royalty has to be determined. Was it quantified in the?
No, royalty was the state, whatever the state royalty.
It can enhance, it can go. Yes.
So the royalty nomenclature was whatever was royalty payable and so this is not this is a site for some kind of a trying to fix up our auction price. This royalty plot is as per the MMDR Act. So there is this is something which is so now please see the larger picture now. The larger picture is not today. If your lordship will see ease of doing industrial business. Where is Orissa coming? Orissa is at the bottom with Bihar. I'm from Bihar. I'm sadly saying so both of us are bracketed together at the bottom. Industrialization also at the bottom of Bihar. Why this is happening? Because this is what you tell the industry and then from the what ultimately when an industry gets in the form of some kind of a incentive to set up the industry. Ultimately, industry plows it back only not by industries. Not if a lawyer not makes money, he buys a house and property. But in the industry, if he has money blood, he only makes more industries. He doesn't not take it away. Ultimately, it goes back to the state. And today, blood by cumulative investment in the state because of this original promise is 1 lakh crore. 1 lakh crore. 80,000 crore direct, 20,000 crore indirect. And I am contributing to about 20 lakh employment. The employment that I'm getting for the lakh people I'm getting employed. I was asked to set up in a place called Kalahandi. Kalahandi, there was almost impossible to reach also at that point. It was a tribal. Incidentally, my father was posted there in Barampur way back in 87. And he was invited by the district magistrate Kalahandi to see the tribal areas of Kalahandi. So I also have a personal knowledge of having gone to Kalahandi there. It was a completely backward place. Completely, there was no development at all. This factory has been set up in a completely backward place to give employment to those people there. Now, what is happening, Lord, I'll tell you not sure how this thing progressed. Just have my list out here. What I've done, Lord, I've made a list out here, it is really comprehensive. But in the list out here only I've extracted, Lord, whatever is relevant, so the Lord should not have to open the brief back and forth. Just give Lord, petition is a company incorporated and registered under the Companies Act and is engaged in the manufacturing and selling aluminium products. Over the past 2 decades, petitioner has invested 1 lakh crore. In the state of Orissa has committed approximately 20 lakh direct and indirect livelihood and thus contributed to the state's economic well-being. The dispute concerns violation of a commitment made by the government to the state-based end-user industry towards assurance of a stable pricing mechanism and availability of 150 million tons of bauxite to run the alumina plant by various interim orders of the port. The petitioner has been lifting bauxite at 1,000 metric tons, which is also not almost under the original agreement. 1,000 is double. This amount is much higher than margin of profit of 50% envisaged in the 2018 policy. The last discovered price of 673 and the 2018 policy. Total 14 auctions have failed since application of the 45(1) rule while calculating the floor price. No weighted average price has been discovered which could have been made applicable to the LTL consumers. This is long-term consumers. As per the policy or agreement, the government of Orissa has notified the 2023 LTL superseding the previous LTL policy and removing application of Rule 45(1) as stipulated in the 2022 policy. Yet, notwithstanding the 2023 policy coming into effect and removing the obstacle of 45(1) to calculate the floor price for the national e-auction, OMC is still definitely and obstinately using 45(1) to calculate the floor price which is an affront rule of law, an attempt to overreach cabinet decision of the state. So I just begin give just a small background before I proceed. At some stage, they wanted to use a particular rule for the purpose of saying that this rule now requires us to calculate the floor price at a particular way, in a particular way. And accordingly, we have to do it from that day. Interestingly, the rule came in 16 and they did not implement it till 19. They are implementing only when the rule is amended. It's only when the rule is amended, they are wanting to implement it. And that implementation also, not the central government has said that this rule is not for the purpose of sale of mineral, merchant sale. This rule is for the purpose of only a mine block auction to be done by the various states, where there is to be a formula to decide the value of the mine. What is the mine? So, comparing the two activities, when you auction a mine block, the only incentive or only objective of a state is to maximize revenue. Because you're auctioning a mine block, that is after the one large permit.
That's the purpose.
That's the purpose of auctioning. But when you give it like this to a long-term consumer, you give it because this consumer has come in and he is set up industry and he is providing employment. He is contributing to the revenues of the state. So the central government itself has clarified, because there was a challenge to this rule in the Delhi High Court also. The central government has clarified here both that this rule does not apply for your sale. You are free to determine your price. They categorically said in this court also, is that rule and that affidavit. Unfortunately, central government has not filed an affidavit in this matter, although they are a party, because we challenge the rule. But in the other matter, not in the Bharat Medium matter, they have filed a categorical affidavit, which I have placed on record.
Before submitting my land, senior is regard to this present situation is concerned, because the Bharat well and the counter filed with the Supreme Court of India. That part didn't have any instruction in spite of my communications. So my lord, it is my submission before this court. Either they're ignoring the virus, all these things, there's go, this OMC can argue the matter. Or if you want to this challenge of the virus is concerned, then I have to take time to take further instruction in this regard.
But they have not filed any affidavit so far.
Yes, I
This is not fair for your lordship. This for hearing.
Was there direction for exchange of affidavits?
No, just now get me.
Just no.
21 side 24. 21 10 24.
That was the direction. There was a direction.
They just brought. 1 week further time is allowed for filing counter affidavit. And they, on the last occasion, they said that they will not file. Basically, that means they want to rely upon that access.
That's why once again I sought for instruction, but as yet I have not received it.
You can't improve upon the affidavit, they've already.
When I take the lordship, I will have.
Instruction in Balku case, whatever instruction they have filed, whether it is the issue is similar to this case or not, and whoever is required to file the affidavit in this regard. That is not
permitted. You are permitted to file. The extension of time was also given. Let us hear so far as the nuances of the.
admittedly they have annexed the document as far as Balku is concerned.
The provision of the act is concerned, that we have, it's a pure position of. So we can proceed on that basis. Let us hear that what we make out.
What I am saying before.
No, that's I appreciate. It's.
So please see not now the list for date in this background. Just see the list for date.
So you are banking upon, you are taking a plea of a promissory estoppel as.
That's right. That's right. Promissory estoppel at a time when the regime was very different, and you are, because of the regime change, only wanting to extract a pound of flesh. Although even in the regime change, you can still continue to be
Only a pound.
Yes. Lord, someday your lordship will also have to look at industries like Vedanta has pledged 20,000 crore for only social activities in this country out of its own personal funds. So, an industry lord who is doing firstly investing in state like this at a time when state wanted them to invest heavily, and also doing social work, whether this kind of a promise should be permitted to be resigned from. I mean, I can understand if you are spending 5,000 crore in a wedding, then probably court can take probably a different view. But this is the person where he 20,000 crore of his personal wealth. He has not please. I didn't want to not. I just said it in lighter way. Lordship will not take judicial notice of that. Lord 7/6/2003. MOU was entered between Department of Steel and Mines, Government of Odisha and Sterlite, now Vedanta, for setting up of an aluminium refinery complex in Laliganj, which would include setting up about 1 million ton per annum aluminium refinery, 3 million ton per annum of bauxite mining facility, as well as installation of 4 by 25 megawatt captive power plant at the aggregate investment of 4,000 crore. But then 4,000 crore was a big sum. The state government agreed to provide all help, prevailing help in prevailing incentives and facilitate clearance necessary for aforesaid project in the state of Orissa, consistent with the various constitutional and statutory provisions related to the said project. Now, when I say consistent with the statutory, then there was no requirement of auctioning, there was no requirement of price discovery. The Orissa Mining Corporation to take necessary steps for executing an agreement with Sterlite with the approval of the state government for all matters relating to bauxite mining. Notably, the transfer of mining lease from OMC to Sterlite would be considered only after Sterlite has made substantial physical and financial progress towards implementation of the project to the satisfaction of the. So this is the clear. Then Lord, please see next day. So this is already written here. Incentives which are provided. So I was only getting incentives with the state government. Otherwise,
I asked because in many states.
So here also there was. That is what my junior is pointing out.
This is in order to invite many
There were
entrepreneurs to come and invest in this, so that they will really assist in the development of the states.
That's right.
Incentive policies are always adopted by the government. Just to,
And the
may I
more
use a very loose term, to attract entrepreneurs. That's why at the very outset, is there any incentive policy?
no, there was a policy which was used, which was in existence, and we were consistent with the incentive policy. Lord, if your lordship will see, state governments have been, some states give free land, some states do not give free power, some states give sales tax exemption, some states, and in every case, Supreme Court has said these are to be followed.
Is it to deal with those points in other states? So that's why I just asked.
Your lordship is absolutely right. There is an incentive policy here also.
Yes.
Then Lord, then see, this is very, very important. For 5, 10,
2004 was entered into between you and the AMC. Oh,
yes, just see the clauses I have quoted here. Pursuant to the aforementioned, MOU was agreement was entered into OMC and Vedanta, a subsidiary company of Sterlite, for setting up of an integrated aluminium complex in
so these are the
Orissa.
conditions to set up integrated aluminum project and all everything. This
Yes.
was a main.
This is the main of. Now, Lord, please see the relevant part is Lord 2.2. In fact, let me read the whole of it because it is a little important. Pursuant to the aforementioned agreement was entered into OMC Vedanta.
So the government also have a stake in that particular mine, because when you talk about JV against joint venture agreement,
That's right.
so they must have some kind of a.
It's in any case a fully owned non-government subsidiary, so it's an undertaking. So it's not a question of not any private. As far as OMC is concerned, OMC is 100% government. 100%.
No, that is true. The JV talks about that means the government's participation, the government's share is also there. What is this?
In this, there is no government. In our, there is no government. There is no government. Just see.
I have come across with one I dealt with. That's why I.
No, here there is no government. Here is only a simple direct investment. Percent shareholder is the government, but that's a different story.
I was dealing with one of the case there. Then it came for when the parties have really fallen apart. on the agreements. So the agreement was when you need that the government has invited, that you come and invest, the private entrepreneurs. And then it was, the process says that after they come and agree to this, there will be another company. It will be,
Joint venture.
it will be a joint venture company where the government stake would be of a certain percentage.
So here there is no
shareholding.
such thing.
And the private
That is
individual
also
also
done.
have a shareholding on certain percentage. And this company would run.
No, that happens invariably.
So that is what I was creating
No,
an
so-
impression that whether JBA.
No, I tell you, Rashid, that happens invariably when the government also has a stake in the state, either it provides free land or it does something additional than just simply giving incentives. So it actually participates in the equity of the company. For here, there is no participation by the government. We
That
only
was the
spend.
case of equity.
So there has to be
The equity government acquired from the fund of the private individual.
no. For the
When the
ultimately
unique
it's what
agreement was there.
ultimately
Very
it's what-
unique agreement which says that the private entrepreneur will pay of money to the government. And this money would be kept and will be treated as invested in a joint venture company to determine the shares of the government. The government did not spend a single penny, but.
in that case, probably the case that your lordships have dealt. Yes.
Anyhow, yes, sorry.
So pursuant to the above mentioned MOU, an agreement was entered into between OMC and Vedanta, a subsidiary company of Sterlite, for setting up an integrated aluminium complex in Orissa with an aluminium refinery of about 1 million tons per year capacity in Laljiganj, in the Handi district, to be catered by the above mentioned bauxite deposits and so and so, along with another mine, both such mines having a cumulative deposit of about 150 million tons. Besides a 6 by 120 megawatt captive power plant and aluminium smelter of about 2.2 lakh tons per year by capacity at Mukhamanda, so and so Jharsuguda district. To set up such aluminium complex in Orissa, OMC had decided and agreed to enter into a JVA with Vedanta on certain terms and conditions. In the a mining lease is not granted by the government of Orissa for the so and so mine, any other bauxite mine having at least equal quantity of bauxite deposit, subject to having at least a composite quantity of 150 million tons, when taken along with Laljiganj mines, shall be made available by OMC with the due approval of Government of India, Government of Orissa, and all references contained in herein in respect to the Karyat mines shall apply mutatis mutandis to such other substitute mines as and when Vedanta proceeds to set up an integrated aluminium smelter in the state of Orissa. The pricing mechanism agreed was as under. The long-term purchase price between Vedanta and OMC for the purpose of bauxite mined from the mines shall contain the following key provisions. The bauxite raised by JVC shall be purchased by Vedanta, paying OMC an amount which will comprise of number one, raising cost, which is the cost of extraction. Two, a sum of money calculated in clause B. Royalty, of course, whatever is payable to the government, and any other statutory dues payable by the state government, other constitutional and statutory dues. In the event, and up to the time that only the refinery is operational, Vedanta shall pay to OMC an amount equivalent to the royalty at prevailing rate for every ton of bauxite mined. In the event and from the time when both Vedanta refinery and aluminium smelter are operational, Vedanta shall pay OMC an amount equivalent to 50% of the prevailing rate of royalty for every ton of bauxite mined. Provided further, however, that only 50% of the royalty shall be payable in respect of all bauxite which is eventually converted into aluminium. Notwithstanding that it is mined prior to the commissioning or in the absence of aluminium smelter. The condition precedent was coming into effect of a long-term purchase agreement shall be conditional upon completion of the construction of refinery. MOU dated 7/6/2003, read with this 5/10/2004 was State of Orissa's solemn assurance to Vedanta of firm pricing of bauxite. Now, Lord, I'll pause here for a minute. The rest of the late will go a little on a slight tangent because that is why I said the matter is going off the rail a little bit. There, I have a prayer also in my petition. For the simple reason that I have not made, I have not asked for enforcement of this agreement. I have gone, I entered into another agreement with them, which was where the price was also similar to this price. Higher, but similar to this price. Now, this price that I entered into with them, thereafter, Lord, this rule came and the state thought that now this is a milking cow. Let me extract more and more money from them. And they have now gone on a route, Lord, which has actually gone on a complete derail. So this prayer in the writ petition is not there that I should be given 150 million ton of bauxite at the rate prescribed in the agreement of 2004. So that if your lordship consider it appropriate to give the central government a short 1 week time, Lord, I can also not smoke. It's more of a formal amendment. I'll just add some grounds and make one prayer, add one prayer in this. That's only I thought I would point out at the beginning, Lord. I don't want to argue the whole matter and then Lord, your lordship will see, but this we would have pointed out at the beginning. Because what has happened thereafter is only in my respectful submission, Lord, the states or the OMCs in sudden realization that now regimes have
What is the point of dispute? How the reason when they have varied the price or increased the
If
price?
your lordship see a couple of more days, it will be clear. Your dispute actually
Let us first have
yes, I'll tell you.
a glimpse of it.
Yes,
Because
yes.
we do not know the core
I appreciate it. I
dispute.
appreciate. So then please see Lord 17.9.14. This is they came up with another policy. Since many industries continued facing hurdles in getting assured supply of raw material, the government of Orissa approved notified the policy for long-term linkage of iron and chrome and other minerals for MOU signed countries of Orissa through like notification of 4662. Inter alia stating that industries have fulfilled their part of the commitment. LTL was allowed for iron ore and chrome respectively for 5 years. The relevant portion is quoted below. Now, Lord, just mark this point, by which time I had also come for, my plant had come in 2009. Now, please see what is in quote. Similarly, in the case of aluminum projects, government has signed MOU with 3 companies. These industries, having fulfilled their part of the commitment, are expecting the state government to fulfill its part of the commitment, especially with reference to making of arrangement for meeting the requirement for raw material. And whereas in spite of the aforesaid measures, the supply and price of raw material has exhibited strong volatility, thereby bringing in an apprehension of financial uncertainty and instability for the industries. Moreover, the issue of assured raw material through long-term linkage has also been agitated by various industries, not only before the state government, but also time and again during reviews done by the project monitoring group of the cabinet secretary infrastructure development. So they are alive even up to 14 that they have to abide by their commitments. Now, Lord, 16 onwards is Lord post Mohanlal. Mohanlal Sharma came in 14. Manohar Lal Sharma came in 16. Supreme Court said that no mine should be auctioned. There is no question of giving any mine to any private person. So that regime has entered later. Using that regime, they are wanting to block, and that also they have just see the couple of more dates, it will be clear. In exercise of past conferred by
MMDR Act was in.
No, MMDR is 57.
2016 that came.
This MCR came in 16. Mineral concession rule.
MDR.
MMDR is 57.
That rule making power. This rules was
yes, so
enacted in 2016.
MMDR is 57. Not this rule.
Yes. I got it.
In exercise of past conferred by section 13 of the MMDR.
And then 45(1) talks about the formula for calculating the average sale price.
Now this 45(1) Lord came in 4/3/16. Notwithstanding that, they still enter into an LTL with me. Just see that LTL, your lordship will see that.
Yeah.
At 24/2/18.
That is policy.
That is commitment to the policy. This again, Lord, is this only in the box, because in the earlier policy, Lord, bauxite was not there because it was only Lord chrome and iron. So here they include bauxite also. And they provide 70% of saleable stock shall be made available. This was bauxite only, only iron and chrome for long-term linkage to state-based end users.
So it really bifurcates that the 70% of the produce will be given to the state for its,
People like us.
for its end user, and the 30% will be sold through national auction.
That's right. So we are not dealing with that 30%. We are dealing with this. We are the long term. Just one more block fact which has not come block. Then there are two other industries in Orissa on aluminium and Nalco. Both have their own mines, captive mines. And by virtue of Mohanlal Sharma, they can't give us any mine, captive mine now. Both are not paying anything to them. They are only doing the extraction and using them. They are paying only royalty. One is a PSU, one is a private sector. And Nalco is not Birla's, and Nalco is PSU.
there.
But both are not only paying. So just see the inconsistency in the policy of the state. You have basically three large players in the aluminium sector in this. And today, why is Gujarat number 2? Today, now I was just checking up today morning, Maharashtra is number 1, Gujarat is number 2. Gujarat even today is giving 500 rupees per metric ton. Even today to the aluminium industry. So this is how you encourage investment and you abide by your promises, and then you get the advantage of additional investment. But if you go back against solemn assurances which you give when the person comes in with money, and then you say, no, I'll now extract my pound of flesh. This is how the state ultimately suffers. So now please see 2-3 more days.
Yes.
Weighted B clause B, where the price arrived at from the national e-auction to be long-term linkage price. And then floor price for the national e-auction may be fixed at the cost of production plus margin of profit, 50%. And 50% was the margin of profit on the cost of production. This is the only formula which is approved in this 18 policy, which is what I agreed to. This similar, there was 50% royalty, here it is 50% profit. So this is the formula that I agreed to. Now, Lord, just see. This is hard. Now, Lord, please see. OMC published expression of interest for long-term linkage with OMC for a period of 5 years by state-based end-user industries for purchase of bauxite, incorporating the 2018 policy verbatim and clause B. The issuance of the 2018 UI signifies that the intent of firm pricing of bauxite sale was clearly in license by the OMC, where floor price for the national e-auction was to be fixed at the cost of production plus margin of profit. Now, this is what we were happy with. We came out of the original 2004 agreement and came here. Pursuant to the 2018 EOI, the petitioner rose to the OMC seeking its continued support for bauxite security and so and so. And for entering into an LTL agreement with the petitioner in the 2018 policy, Vedanta undertook that it shall pay the price of such ore as and when discovered by the auction. Further, it is confirmed to pay the specified weighted average price arrived from the national auction towards the appropriate grade of mineral lifted from the long-term linkage agreement. Vedanta also stated that Vedanta has invested by then we had invested only 42,000 crore in setting up state-of-the-art aluminium, world-class aluminium and power complex. Also at Jharkhand by creating 50,000 direct and indirect jobs. The said investment was possible based on the firm assurance made by the state government to make 150 million tons of bauxite. Now, 150 million tons I've been repeatedly saying even till now. Then, Lord, 418. First, the national e-auction of 190,000 metric ton of bauxite, there is no complaint basis, was conducted by OMC. As per the 18 policy, the floor price kept was 462. The auction was successful, discovered price was 465. So this is the price which was applicable for me, the first price.
Because you have agreed that you will be paying that.
Yes. Now this also is much higher to my 2004 agreement.
Yes.
But the fact that so my mistake was that instead of all the time insisting on my 2004 agreement, I came here. And from here, your Lordship will see how they are taking me in a different route. Now, Lord, when this was done, 465, the rule had already come. 45-1 had already come. 45-1 had a different formula. They didn't apply that formula. They gave me in this rule. So obviously, 45-1 is merely a ruse to arm twist me. 45-1 is not something, Lord, because even when I go show your Lordship 45-1, 45-1 is also an average sale price. It is not a selling price. And the purpose of 45-1 is, which is in their affidavit, the central government affidavit, that it arose because Chhattisgarh had a problem in getting price discovery of the value of the mineral for an auction of the mine block. So for that purpose, 45 months. So that is why central government clarifies that this doesn't apply for merchant sale to us. It's only for mine block auction. So 45 months is used by them, and your lordship will see that later. Then block 24/4/18. Long-term linkage sales agreement for bauxite was executed between OMC and the petitioner for the sale of bauxite in so and so to the petitioner's plant. So it was period of years of 5 years. Annual sales capacity so and so. Price is not the price is the same exactly as what I read earlier. Saleable stock of a particular product of OMC will be divided into two categories: linkage quantity and auction quantity. The linkage quantity will be sold state postal users. The auction quality will be sold through national e-auction. And then see the underline. The weighted price of a product derived from national auction will be fixed at the sales price for that particular product to be sold to the LT consumers under the LT sales agreement. Therefore, the long-term sales will be changing continuously with each auction. Then, Lord, second year auction took place. Here also, Lord, it is 553. 548 was the floor price and 553 was the discovered price. And then third, the auction also takes place where, Lord, the price goes to 673. So by this method of, Lord, extraction cost and 50% profit, I was happy. It was much more than what I was paying, what I was supposed to pay under the 2004 agreement. But why, because I have come in this matter only for the first time, why we need to get out of all this and go back to the original agreement? Because, Lord, this will ultimately take me to only to 23. This agreement is, today we are without any formal agreement. So if I have to, that is there, but that is the caveat. So ultimately, if to go to the original assurance, I'll have to, Lord, add that where in the rate petition. Now, Lord, at least what happens thereafter. Third auction also, your lordship have seen takes place 673. In the third auction, bauxite ore was 673. Then, Lord, now please see 10/7/19.
Consolidated LTL policy.
The government official published the also has amended till date clause D. Here also it's a reiteration. Then, Lord, petitioner OMC requested petitioner to resubmit up-to-date documents also for re-registration of OMC for taking part in national e-auction. Then, Lord, this petitioner submitted letter, but they never did any auction. And, Lord, and they stopped supplies to us. Then, Lord, 29/19 is the amendment to the rule. Amendment to the rule. The rule is of 2016. Since, Lord, 18 to 19, they are supplying us in spite of the rule. This rule is amended. And this amended rule now they want to only enforce for the purposes of fixing the floor price. The Ministry of Mines, Government of India, amended mineral so-and-so rules. In 45(1), rules has been substituted. Average sales price has been redefined. The state government shall arrive at the average sales price of medical, metallurgical grade bauxite in the following manner. And then there is a formula. And then, Lord, wide another notification, conversion factor has been stipulated at 6.4%, which is based on the London price of aluminium. In the 2015 rule, the conversion factor was not there. So without the conversion factor, the price was working out to something like 23,000 rupees. After the conversion factor, it is working to something like 3,000 rupees.
According to you, this amendment which is brought in 2019, where so far as the calculation of the average sale price is concerned, according to you, that really goes contrary to what the earlier arrangements was there, what the agreement talks
That's
about,
right.
and what the promise which was made.
Absolutely. And also, Lord, it is also explained by the central government at all. That is how the central government is wanting to protect the rule. They don't declare it ultra wide. This is not
for the central government has said that this particular amendment
the rule itself. They say the rule itself is not for us, or the amendment. Both is not for us. That is their affidavit, which is in the other matter, not in our matter. That is their affidavit. Then, Lord, in spite of this, when they came up with this rule, then I filed this first state petition. And then, Lord, we are in the series of petitions. We are, no, this is so two people. So we filed a petition, And thereafter, in a series of orders, Lord, we are being protected, and your Lordship are saying, all right, as an interim measure, pay 1,000. We are paying 1,000. And there is a complete embargo up to them to raise anything other than 1,000. But what they are doing and why they are wanting to block, I believe last date they said 4,000 crore, etc. What they are doing, in spite of the auction failing, in spite of no bids coming, they say we will apply the rule, the price in the rule, and you pay me in the rule price. And now, Lord, why again? There is another problem for me, and that is why, Lord, I feel that in the latest auctions, there are some people who have bid 3,000 also in the latest 2-3 auctions. Now, that, Lord, are small quantity. The Lordship knows, Lord, in like taking the land acquisition. A
A
small
large
piece,
tract of land and a small.
small. It can't be completely
Comparable.
it's not comparable. So that right. So ultimately, if I don't, Lord, have the relief of 150 million ton at the original, Lord, this will be a problem. In my respectful submission, this is what I felt after going through.
So you want to bring by way of.
I want to just add a couple of grounds
The grounds and the.
and one
relief
prayer.
For renewal or extension work.
No, I want a prayer, Lord, saying that the state is bound to pay me, supply me 115 million tons of bauxite at the way in which price was to be determined, which is not the extraction price plus which is in the original agreement. In fact, they also initially thought the same.
Subsequent thereto, there was an agreement which postulates the mechanism of the formula, how you have to pay. Then secondly, there was a deviation from there, you have agreed 70-30. And then you have.
And 70% price,
You have also
national
agreed that the particular price which you be quoted, you will be paying that, there is no dispute in the regard, and you agreed on that.
And I agreed the floor price will be
Now the price is quoted at a very higher and
in the very decent auction.
whatever,
14 auctions, there was no bidder,
whatever. Then,
no price discovered.
so now can you fall back to the original law?
Lord, that agreement, that is all. I'll show from the pleading, Lord. That is why I don't need to change my pleading. My case consistently has been that there is no assurance of the.
Was it not an implied novation of a contract or a novation of?
No, Lord, because that contract is only for 5 years. So let me assume for 5 years there is a novation. I can't get any refund for those 5 years. But for the whole 150 million, I can always say that barring the novated amount, I should be not permitted to be supplied the whole of this in terms of the original.
Let him bring and you also bring your affidavit.
Yes, yes. But my lord, only one submission I have.
I think for the OMC, my lord. No, we will be objecting to the amendment of the petition. Because that has never been the case in this present petition.
I should have
But after 2 years, they want to amend the petition.
Now certain facts have originated
No, it's
during the pregnancy.
not during the pregnancy. That's
New fact. I'll
there, but now we want to bring the 2003 or 2004 MOU.
These
small 2004 MOU.
these
want to
small
bring in again.
quantities have come in auction.
The whole kind is in prayer in this petition. But this is changing the whole character of the petition, which cannot be allowed.
You can have your
They are
objection.
going to not change the character of that petition. The whole kind is prayers in that petition. What are the prayers? There is no prayer for MOU will not be enforced today in 2004.
No agreement is
That has never been their prayer.
MOU converted into an agreement.
But that is not kind of the prayers. Page 155.
That is why I need to change the prayer.
They can't change the prayers, they're like this. After 3 years, this started, the earlier petition they withdrew. They were enjoying this stay for last so many years. They've been enjoying the interim order. Can you see the prayers? But they had earlier withdrawn the petitions. They could have made their prayer. Two petitions they earlier withdrawn. They had earlier withdrawn 2 petitions. This is 3 petitions. This is the 4th petition. And no such prayer was made in any of the petitions.
I know friend is a answer the amended prayer. That is why he's
No, question is not that.
opposing.
Question is they have the right.
First is a very interesting prayer. First is a very interesting prayer. Anyhow, B, I have seen. Then
Very good.
C is the other prayer which I was not original prayer.
B also, yes.
Little same similar to C.
Yes.
E is the representation which your lordship permitted in the earlier representation which got rejected. So obviously quashing that.
Yes.
And then obviously the demand, etc.
Yes.
But I'll show blood the whole pleading from the petition is all based on that 2004 agreement. Even by letters, even by latest letter to them, which I will also place on record, is always not saying 2004. Because that is important not for the promissory estoppel judgment that I'll be relying upon. Because if I don't get the promissory estoppel advantage, then I'm first stuck with these agreements.
No, that is what they have not, but in the none of the petitions which they have filed, which they have withdrawn. No, that point was raised today, my friend cannot get respect. Similar, now I want to raise that promissory estoppel.
Promissory estoppel is there. Only the prayer is not there. I'll show that one. My friend did not labor of this on as far as that is concerned. Promissory estoppel is there. The whole petition is based on that agreement. It's on record. It's not in time to argue outside. 6-9.
But kindly see that the earlier prayer is at 6-7.
Looking at the prayers,
My
one by one.
My lord.
Definitely, what he's arguing is
My lord.
completely not there.
My lord. So even in the earlier petitions,
The factual foundation is just 145.
Lord, page 669, earlier it petition all same similar prayers.
If we get a factual foundation.
It's there. It's there. Just see page 23 onwards.
But for a moment, in the earlier petition they had filed. But
All
start
these
657.
I'm not arguing anything outside the facts now.
Yes.
Only
And
ground.
you see the prayer at page 657, the earlier petition, which they have withdrawn. This issue was never raised. They are now trying to rake up, my lord.
What is thinking way of
My lord,
the cases are concerned.
My lord.
I am very expressive
My lord.
and I always open my mouth.
Well, that's always brought to the.
So that is what is.
It is good for us also.
Because I have here
My lord.
in another high court
My lord.
that if we find a foundational fact
My lord.
there in the
My lord.
records,
My lord.
merely an if there is a foundational in the
My
fact,
lord.
the very fabric
My
of the
lord.
fact is not
Just page 23.
But
is not disturbed.
But
Then
even-
this argument,
but they
I am
have.
bound by my own judgment, which I am telling you.
Just see page 23 onward. All this is, I'm not reading anything outside.
But they
Whether
have.
they can, I put up one questions to him,
My lord.
and I think as the senior counsel, he has answered
My
it.
lord.
Innovation.
Whether it comments or it does not comment.
My lord.
So he has to justify
My
that.
lord. My lord. But let them not first show, my lord, that this is not the first petition. They have filed two earlier petitions on the same cause of action, in the same context. This issue was never raised.
You have judicature.
But those not, but not that.
We were permitted to come back.
But that is what I'm trying to show is.
I don't understand. Today, your lordships are not allowing
Even those
you.
petitions,
Why for keeping on a technical aspect more?
but not in technical aspect. But the point is not the whole thing is getting delayed for the last. I am not.
We are not denying it because the getting a delay because the central government stand.
Okay.
See, they wanted the affidavit to be filed despite twice opportunity being given.
My lord.
They are not. Still today they are asking.
My lord.
This is what
We could have permitted to do it, but we just wanted to know that what is the
My lord.
the
controversy.
I just wanted to see.
My lord, sir, I appreciate that.
so that we can squeeze the point of consideration to a limited.
My lord, I appreciate
So
it.
you have to give them an opportunity to file affidavit.
I appreciate that. No, the course.
That is what is there.
And I am only going to file an application, your lordship will have to consider on the
But I
next day.
find the virus is an alternative prayer.
That's it.
It's an alternative prayer. It's not a substantive.
It's not a
prayer.
substitution.
Yes.
Let my friend, Lord, let my friend withdraw the petition.
Look at it. That's how an office means.
We were permitted. We were
But let my friend, Lord, in case my friend wants,
Adhere to amended rules.
well, if my friend, Lord, wants to amend the petition, let him file an application. Lord,
I will. I'm only saying, I'm not asking your lordship to allow it today.
My lord,
Will it not take around to delay?
Lord, I'm not, I file, let him file within a week, I'll file reply within a week. I don't want this matter to delay.
That is up to you. We can't stand in the way. But
But I want to not place all the
we have to
facts.
give them a time.
My lord,
Even if no leave is granted by the court,
My lord.
does it create any fetter in them in taking out an application for an
no, my lord is right. But I won't say.
And only thing is order 6 rule 17 has to be applied.
That's
We
right.
will consider it whether
That
it
is not-
will be allowed or it will not be allowed.
But that issue is there, but they want to add something more. They want to go beyond the melody.
No, I
Then
find
what is the purpose of incorporating the order 6 rule 17? It's now the court whether it will have to consider whether it will allow the amendment to be carried out or not to be carried out. But we cannot prevent a party from taking out an application for him.
I appreciate, but at what stage is the question? After the stage operated.
Of the proviso inserted by virtue of 2002 amendment. I am conscious.
My lord is right, but after that they have filed how many petitions? But while this prayer, but that's why I would not normally object to the innocuous amendment.
Well, let us see if they want by.
If it is pleaded completely in the petition, if I'm arguing something, it is not pleaded.
My lord already indicated to me, but I want to show, my lord, that in the other petitions which they had filed, can you see the prayer at page 656?
The scenario was different then.
But
There was
they were not different.
There was no
It's
discovery of
after the rule only.
Now there is a.
This one.
My lord,
If the earlier writ petitions were filed,
my lord,
it was withdrawn with the liberty to file a petition.
my lord.
Then can you say that they have not pleaded there? Because why the liberty was granted?
May I?
Why the liberty is granted? Liberty is granted because that application may contain a fatal defects which is incurable in nature, and that's why the court has granted them a leave to file the same. That does not mean that they will be precluded from claiming anything. It has to be treated independently. This petition.
But great respect, that was not the ground. It was not the ground of that ground.
Can they not? Suppose the liberty is granted.
Why
Can
not?
they not reframe the writ petition?
But they can, but even then they have not.
With
Submission
certain
is,
more prayers, that can be done. So amendments, we are not applying our mind. We are not really coming to a conclusion because we have not seen
my lord,
what amendment they would make
my lord,
to bring by way of an
my
amendment.
lord.
It is all the should to be decided when the amendment application would come.
That's
We can't prejudge, we can't presume.
My lord,
Something
you're right.
which
Bro, I
would
want.
destroy the very core
I
thing of the
fully
Definitely will not
appreciate.
permit
Bro, I'm
or
fully
resigning
my
of
lord.
the admission if they have already made. We will not permit them.
But I fully appreciate that. Let my lord, let my friend file an application within a week. I reply within a week. And then look up, I am
and
not
they should be
worried.
given
Because
whatever time they want.
the difficulty, my only difficulty, my 4,000 crores are due today.
The 4,000 is completely not a bogus.
It is not bogus. But I am very sorry. What is
You are
bogus, my friend?
ultimately-
I can also say my friend's name is bogus. I can also say my friend's name is bogus.
Please consider this interim order is operating
Since 4 or 5 years.
2023, I believe.
My
No,
lord,
earlier also not.
No, 2023.
But that
Disparate
is why I am not very concerned.
Consider this court has taken
First
after matter so that it can be brought to its logical
My lord, I am not
conclusion. So
grateful for that.
that is why we wanted to dispose of the matter.
My lord, I am not grateful for that.
Feel that it should not be disposed of, we are happy.
Yeah, I wanted to dispose of. But since my friend has come out with a new ground for the first time today,
If it is
when he has come,
pleaded, I will only
If
do
the
that.
party
my
wants to
friend
amend-
in genuity, I
you
appreciate.
defend the application for amendment. I know.
But I do not want this issue to be raised.
I was just trying to expedite the matter that whatever, let it be decided one way or another.
No, yes, that with great respect, not whether today the ground can be raised is the issue. After all these years, whether the ground can be raised is an issue. That's why I would not normally object to amendment. That my final application within a week will reply to it, my lord may decide it.
The matter was argued without tension. At this stage, he submitted for the facility. Whatever. Availability of the senior counsels, availability of the DSG, availability of the HE, everything.
But 4 December,
Yeah.
Before this was already.
Any date, just give me a date,
4 December.
which is acceptable to all.
I will vote whatever not my friends said, I will agree because otherwise I would have asked if it is not we can do.
5th is all right. We can
Friday is something,
5th is a Friday.
because there is this court, but actually there are many, the other benches that really conflicts.
Then you got 8th, not
Whatever,
It is Monday.
everybody you just.
8th is all right.
But let it not then again their holidays will come thereafter. Again, not can only have it not in the first week.
Holidays will be in the third week.
My lord, sir.
No, we'll go.
But the amendment at least can not.
So I was suggesting first, but that was not suiting with that was second.
Fourth, can you?
Mr. Mehta is also appearing for any party.
Which Mr. Vikas?
I do not.
Well, not, I'm appearing with Mr. Vikas Singh. He's leading us in the matter. Malone.
Oh,
He's leading us.
he is appearing also in the matter. Okay.
Third appearance.
That's right, Malone. For the same party, Vedanta.
Okay.
Third is all right. Third is my friend there.
Third is all.
Yeah, okay with you.
Third. Actually, want us to continue.
If it is already there, it has to continue.
Yes, Lord. If you want us to continue.
Mr. Sahu wants to say.
What?
Only interim order. They will be asking me to ask interim order.
We are more interested in the
I know.
interim order than anything else.
Unfortunately, the last order says till next day. That is why your lordship has to say till to continue.
Till the next day.
Just partners. But just now that the lordship posted it back to the third.
I couldn't for fourth day for
Our method.
The 4th of December?
4th of December.